So I want to welcome everybody to today's presentation, and I want to start today by acknowledging that we are here on the treaty and traditional territory of the Mississauga and Anishinaabe at Trent University. And I will turn it over to Lynn.
Miigwech Don. Yes, Trent University is located in the traditional territories of the Mississauga and Anishinaabe. We are delighted to be able to live and work in this territory. You will perhaps, with an international audience, people are coming from many different places, and perhaps you would take a minute to just write into the chat the territories that you come from and the treaties that have made these lands available. We're talking about strategic change and the use of framing in order to spark that change. The team who will be presenting today include Jeff Dennis, myself, Lynn Davis, Don Lavelle, Harvard, and Avro Bell from University of Auckland. Chris Hiller is not presenting today, but is a member of our team. This is the agenda for this session. We're going to begin by talking about the purpose of our work. We'll talk a bit about framing theory and the methodology that we have been using. We're going to be presenting two case studies, A Right to Belong and Shoal Lake 40. And then we're going to be doing a reflection on the framing that we discussed. We're also going to have a discussion with Avro Bell, who's coming to us from Aotearoa. And so there may be some kind of difficulties in connecting, which we hope will get solved in the next half hour. So the purpose of this presentation is to understand the role of framing, and particularly rights framing, in igniting change through the examination of two case studies. There are a number of frames that we're going to be talking about today. The first is a human rights frame and a related frame of social justice, or just simply justice frame. We're also going to be talking about an Indigenous and treaty rights frame and a related frame of Indigenous sovereignty and cultural integrity. We're going to talk about settler colonial frame and reconciliation frame. So to go back to the human rights frame, Canadians really are embedded and invested in the idea of human rights. We have a very robust structure in Canada, the Charter of Rights and Freedoms. Practically every province and territory has its own human rights code. Canadians are invested in equality, fairness. It's part of Canadian identity. It's part of self-perception. And so it's a very potent frame in the Canadian context. Indigenous and treaty rights frame really address issues of sovereignty, Indigenous self-determination, upholding treaties, cultural rights, and this discourse of Indigenous and treaties comes into conflict sometimes with the equality frame, or let's say the equality aspects of human rights frame, where some Canadians feel that Indigenous rights are special rights and are not equal rights. And so there are various tensions that arise in the different frames that between the different frames and amongst the frames that we'll be talking about today. Of course, settler colonial frame is very prominent in our society in terms of critique. This is white supremacy and racism. It's the agenda to assimilate Indigenous peoples. It's control over Indigenous lands and the imposition of Canadian sovereignty over Indigenous sovereignty, and the denial that any of that is happening. So the settler colonial frame is one that we understand in settler colonial studies, and has all those different dimensions to it. We also reference a reconciliation frame, and the reconciliation frame has become more prominent since 2015, when the Truth and Reconciliation Commission delivered its report. It's very popular in Canada. Many institutions and organizations are acting upon the calls to action that the TRC put forward. And it's also a very contentious frame that many people think is artificial, superficial, and performative. So we are also addressing that particular frame. So what is framing? We derive our understanding of framing from the work of Snow, Benford, and others. And we're drawing particularly on a paper from 2018, where called The Framing Perspective of Social Movements, Its Conceptual Roots and Architecture. And there are 5 particular concepts that we have been working with, and I'm just going to describe them very briefly. First is the idea of the master frame, or a really broad frame that, like civil rights, very broad, that a lot of different organizations are able to draw upon in their mobilization work. And we argue that the human rights frame is one such master frame. Snow et al. Also talk about core framing tasks. And they say that organizations and social actors are engaged in 3 particular tasks. First is the diagnostic task, diagnostic framing, and that is indicating and addressing what's wrong with the system and who's responsible. That's followed by prognostic framing, and that is, how do we solve it? What can we do about it? And the third is motivational frame. And that framing process is bringing others on board together. So framing in a way that suggests urgency, responsibility. I don't know about you, but my inbox is filled with motivational emails on every number of topics: civil rights, human rights, climate action, justice, anti-colonial action. So many of us are drawn into the motivational framing appeals of different organizations that have done diagnostic and prognostic framing and are now trying to mobilize. It's in that context that they draw upon, and I should say we draw upon as an activist, various discursive ideas. And so discursive fields refer to the values, beliefs, and ideologies of a society that kind of shape the conversational environment in which we are drawing. And we draw also upon discursive opportunity structures. That is, because of certain ideas within a society, we may actually fine-tune our choice of frame in order to draw upon those ideas that are already in the society and part of the conversation. Frame alignment is a strategic action to link our goals with prospective allies and decision makers. And through that, we use bridging, amplification, extension, and transformation. In other words, we try to connect with others in different ways and to put our messages out in a way that is going to resonate or resonate with those of other organizations, with individuals, and bring more people on board. And so we see a lot of that happening right now with the various elections that are going on. And we see this positioning, this use of particular kinds of language and so on. So that's what we're talking about in terms of framing. And we draw upon these ideas in the work that we're doing. In terms of methodology, our research, which is called For the Long Haul, makes use of a number of case studies. And overall, what we're looking at is what we can learn from long-term alliances that have gone on for decades. Two of the case studies that we're looking at are Right to Belong, which looks at ending gender discrimination, sex discrimination in the Indian Act, and also Shoal Lake 40 and the Fight for Freedom Road and Clean Water. And those are the two case studies that are going to be presented today. Our third case study that Chris Hiller is leading, which is KAIROS Canada, is not part of today's analysis. So we're going to get right into the first case study, which Dawn Lavelle-Harvard is going to present. But before she does, I just want to mention that the sources of the data for this particular case study include a historic gathering that we convened in February, March 2019, where we brought together quite a number of key leaders in the struggle to end sex discrimination in the Indian Act. And you see many of them pictured right here. It's really nice to look at this picture and realize the incredible, the way in which it really was historic. Some of you may recognize some faces there. We also relied on briefs and submissions to international human rights agencies, and Dawn will be talking about that work. And then we're also drawing upon Dawn's experience as an Indigenous leader who has been engaged in this particular struggle probably all of her life. So with that, I turn it over to Dawn. And yes, okay. Miigwech.
Miigwech, Lynn. So when many people ask how I became involved in the Indigenous women's activism and the struggle for Indigenous women's human rights, I admit that I've been involved for over 47 years now because I was essentially born into the movement. I was that child in my mother's arms when my mother, Jeanette Corbier-Laval, began what became a historic court case when she challenged the government of Canada because she lost her status when she married my father, who was a non-Indigenous person, which therefore triggered her losing, her being removed from the Indian registry, removed from her community. And because this didn't happen to Indigenous men, this was a clear case, we thought, of sex discrimination. And so we're going to start our presentation today just with a really short clip, just to have the first voices from Jeanette and my father to describe, that the situation initially when this struggle for the status of Indigenous women began.
I guess just to share with you that.
So right now I can still just see
49 years.
We have the sound, but not.
Okay. We'll just reshare.
challenges come my way.
Perfect.
Jeanette walked into my office with this case, and I'd never heard anything about this issue, had never thought about it. And after we talked about it for a while, my initial reaction was, this is insane. This cannot be right.
I was about human rights, and if part of that was my wife's position on what was being done to her, and I supported it all the way, but that was definitely always and still is a part of human rights.
The federal government therefore urges all Canadians to join it in settling this question without further delay by renewing our federal pact and our sense of belonging to this country.
It has done some good because it's made us as Native people really look at what is happening to us now. How can we allow a piece of legislation to divide us? It's dividing families, dividing friends, dividing people.
Today we recognize that this policy of assimilation was wrong, has caused great harm, and has no place in our country.
Could not bear a system where these ideas about humanity and human rights could prevail over Parliament's deliberate and clear intention.
I think it's time that we actually stood up and took responsibility for the terrible mistakes of the past.
We actually have a piece of legislation on the books that could eliminate all the discrimination against Indigenous women and their descendants, but doesn't.
Respect our laws, respect who we are. Do away with the Indian Act, because if you do away with the Indian Act, you're also doing away with the discriminatory practices.
Once you marry out, then you're gone. We weren't banished from our people. That particular section of the Indian Act was put there specifically to diminish our people. You know, you get rid of a woman, then you get rid of all her family, her children, and future generations to come. Very crafted, I would say.
We've all heard the prophecy that says a time will come when men and women will be equal again, that our people will be strong, and that time is here. They used to say that a nation is not conquered until the hearts of its women are on the ground, and then it is done, no matter how brave its warriors or how strong their weapons. But I am here to tell you that our hearts are not on the ground.
With human rights, basic human rights, has to do with basic, fundamental justice and fairness as a human being, respect to all people.
I pity the country, I pity the state, and the mind of a man who thrives on hate.
So from that brief introduction, that was, the precipitating event of my mother losing her status back in 1970 when she was married, precipitated them going to court and winning eventually in the Federal Court of Appeal in Canada, because clearly this was a case of very clear sex discrimination, because this did not happen to men. They did not lose their status. In fact, their wives and children gained status. And in a very clear case, then unfortunately the government of Canada appealed this decision to the Supreme Court, and they were in fact joined by the members of the National Indian Brotherhood, so the chiefs, and it was called the Indian Brotherhood at the time for a reason. It was, the male chiefs, because you also have to remember under the Indian Act, initially, it was only Indian men that were entitled to run for council or be chiefs. So at the time, it actually created a lot of division in our communities, where we had, as you see, the leader of the Union of Ontario Indians who said, why are you doing this? You're destroying our people. And, saying that this is the way it has always been, but it was not part of our tradition. In fact, Indigenous women, their partners, in fact, joined the woman's family. Many of our communities were matrilineal. So this was not part of our tradition, but there was a lot of propaganda happening at the time, a lot of government people coming out to the communities and deliberately telling the men, telling the chiefs that if you allow this court case to go forward, that there's going, these Indigenous women are going to bring their white, their non-Indigenous partners to the reserve with them, and they're going to be taking over. There was also a narrative about these Indigenous women and their children were going to be a burden on already impoverished, overburdened in First Nations communities. And so it created this division where even within my own community, the chief of our community told Jeanette, told my mother, that you're doing the right thing, that our women and our children and grandchildren belong in our nations. He said, but you understand when we go to Ottawa, I have to speak against you. I have to toe the party line with we had the Indian Brotherhood, not only the National Indian Brotherhood, but the Brotherhood of Alberta, the Brotherhood of Manitoba, and the Brotherhood of every province across Canada standing against our women and making this a question of Indigenous sovereignty. And so it divided a lot of those who would otherwise have stood up, seeing this as a basic human rights issue, but it was positioned very often as our women talking about this being a basic human rights issue, but others saying that this was actually about Indigenous sovereignty, this was about treaty rights, and that created a space where it was very hard for others to see how this would be their issue, because the majority of people across Canada would not be eligible for First Nations for Indian status, and so tended to not see this. They saw this as a, that's an issue for the chiefs to sort out, that's an issue for Indian Affairs, and that this is, an issue for those people. And at that time, Clayton Ruby stood up and said, well, if the National Indian Brotherhood is speaking for the chiefs, speaking for the men, who's speaking for the women? And it was at that time that women like Jeanette, they began to create their own organizations to speak and have that voice of the women. The Ontario Native Women's Association, then Indian Rights for Indian Women, the Native Women's Association of Canada, to be that voice for the women and that intersection of their discrimination, not because they're Indigenous, but because they were Indigenous women. Now, unfortunately, at the Supreme Court, in 1974, it was Jeanette lost by one vote. And at the time, and they lost on a technicality, essentially. And one of the Supreme Court justices said that, she should be happy that a white man would marry you because you're better off, because we all know what it's like on an Indian reserve. And, this was the attitude that people had. And so even though Jeanette lost in the Supreme Court of Canada, because Canada holds itself up as a defender of human rights around the world. I mean, even right now, we see how Canada is, running to protect and defend the human rights of people in Europe, of people in Ukraine, Canada holding itself up as a defender of human rights, and at the same time going against the basic human rights of Indigenous women right in our own backyards. So Sandra Lovelace took this case to the United Nations and used the international protocols to essentially shame the Canadian government into making a change in 1985 with Bill C-31, and those women who had lost their status were reinstated, but instead of instead of returning to their original status, they created new categories of, Bill C-31. Under Bill C-31, they had, created 6-2, or those women were returned as 6-1C, a special category for reinstatees who didn't have the same status that they originally had. And what's really important for people to remember is this isn't just about a piece of paper. It's not about a card. Losing status meant these women lost their homes, they lost their land. In fact, they lost the right to ever return to their communities and to live with our people. So this is why this was about a right to belong in our nations. And it was at this point that there became a separation of membership and status, because the return of women to our communities was framed as it was going to be a burden onto an already overburdened First Nation community. So instead of seeing women as an asset, they were seen as a burden. And the government, because they had to correct the human rights discrimination, the discrimination based on sex, the women were allowed to regain their status and were returned to the National Indian Registry, but it was separated from membership. Each First Nation did not have to take the women back to their community. So their membership in return back to their community, which is what they wanted, was not guaranteed, and created all kinds of new categories of discrimination, all kinds of new categories of Indians under the Act. And then in 2010, Sharon McIver took the Canadian government to court again. And under Bill C3, it was for the rights of essentially the grandchildren's generation, because there was that continued discrimination against the grandchildren, because that Bill C31 only returned the women and their children, but again had created these lesser categories. And then it was not until 2019, almost 50 years after the initial struggle, that under Bill S3, that they finally removed the legacy of sex discrimination under the Indian Act. And all of those women and children and grandchildren were able to return to our communities, return to our nations where we belong, and be reinstated after a 50-year struggle. And so our research project was about documenting that 50-year struggle that relied very much on non-Indigenous allies coming together, because we can take, if I could take every Indigenous man, woman, and child, load them into buses and drive to Ottawa, even if such a logistical thing was possible, it would still be such a small portion of the voice here in Canada that it could be easily ignored. And it was not until we started using, these larger human rights frameworks within, the Inter-American Commission, who are human rights watchdogs, looking at Canada from outside, other countries looking at Canada and what is in a clear violation of our basic human rights as women. And so this was, my mother attending the Inter-American Commission on Human Rights in the middle, and Sheila Day and Fafia, and who had come together as those who were interested in, the rights of women to be free of discrimination, to support the Indigenous women in their struggle for the recognition of their basic human rights, which most people also don't realize. The date of 2012 is really critical here, because in Canada, the Canadian Human Rights Act, specifically under Section 67, said that the Canadian Human Rights Act, which guarantees us a life free of discrimination based on race, ethnicity, sex, Section 67 says that it does not apply to anything governed under the Indian Act. So the Canadian Human Rights Act literally created these human rights free zones all across Canada because it said it didn't apply to our First Nations territories. And it was not until 2008 that was repealed. And because there was a several years delay for communities to implement it, it was literally not until I think around 2012 that everywhere across Canada was finally subject to the Canadian Human Rights Act. One of the most important things that we were able to do when we started talking about the violence against Indigenous women, because the removal of Indigenous women and their children and grandchildren from our communities, the removal of our women from those supportive networks of our brothers, our uncles, our cousins, our fathers and grandfathers, meant that many Indigenous women, when they lost their status and found themselves in urban centers, they were removed from those protective circles, those kinship networks, and found themselves even more vulnerable to violence. And at this time, when we were having conversations about, starting to bring awareness about the extremely high levels of violence against Indigenous women and girls that has been happening for 200 years, but is very closely connected to this issue of status, when Indigenous women were made even more vulnerable. And it was clearly linked in the inquiries that it was this vulnerability created by the status issue that was making our Indigenous women more vulnerable. And the issue of violence that allowed the expansion of that framework, that human rights framework, so that most people, that they could see themselves, they could see this as a human rights issue, not an Indigenous issue, not necessarily a women's issue. When we talk about violence, because everybody has a daughter, a sister, everybody has a mother, they could start to see how the issue of violence against Indigenous women, which is very intricately connected to and combined, integrated with the issue of our loss of status, that legislative violence against our women, then it all of a sudden became not an Indigenous issue. This wasn't about treaty rights. This wasn't about, trying to protect the treaties, trying to protect the Indian Act. which protects our lands, this became about basic human rights, because everybody, you could make this everybody's business. Everybody could understand that fear, that vulnerability of, if it was your sister that this was happening to, if it was your mother that this was happening to. So then this became an everybody issue, every Canadian. And we deliberately went from church groups, we went to labor unions, we went to classrooms to talk about this issue of violence, so that, when the Trudeau elections came up, this actually became a national issue, where we said, this isn't an Indigenous issue, this isn't a women's issue, this is a human rights issue. And this violence against women is a national tragedy, very intricately connected to this 50-year-long fight for our women to have their basic human rights respected in this country. We'll go to the next. And it was not until we made it everybody's issue, when we talked with the National Inquiry, found in its first recommendation that recognizing the basic human rights of Indigenous women requires that the government of Canada immediately eliminate sex discrimination from the Indian Act. Because we can't talk about Canada being a defender of human rights if they're continuing to deny Indigenous women their basic human rights, if they're continuing to deny those women and their children and grandchildren the right to belong to their communities simply because of sex discrimination. And this is where it became very clear that expansion of the framework, of that human rights framework, so that every Canadian could identify and to see that, the allowing injustice anywhere is allowing injustice everywhere. And that's, making this everybody's issue, so that it wasn't just those who were impacted by it, as in, the Indigenous women and their children, but when it was very clearly a human rights issue. If we are defenders of human rights here in Canada, then we need to recognize the human rights of Indigenous women.
Miigwech Don. Jeff is going to present now on Shoal Lake 40.
Thanks. So the Freedom Road case, let me just maximize my screen here. Oh boy. Okay, well, I'm just going to leave it. Hopefully you can see it okay. So
you hit slideshow, Jeff, it should show only that. Hopefully it will. Across the top there, it says slideshow.
I'm just having trouble viewing. Oh, here we go. Okay. Yeah, okay.
And
from the current.
Perfect. And then just flip through real fast. This is good. It's a good review for
there
all
we
of us.
go. All right. So the Freedom Road case, not to be confused with the so-called Freedom Convoy, refers to Shoal Lake 40 First Nations' longstanding pursuit of all-season road access and clean drinking water. They called it Freedom Road because it wasn't just a road, it was a means to move freely on their land and to access jobs, schools, healthcare, other things that most Canadians take for granted. For decades, community members relied on ice roads in winter and a barge in summer, but during fall freeze up and spring thaw, it was extremely dangerous to cross the ice. At least 9 people died trying to do so. Ultimately, the Freedom Road campaign succeeded, but it took decades of hard work, strategizing, and persistence. And today I'll focus on the role of framing in that process. The research for this case included 2 day-long sharing circles, 30 one-on-one interviews with Shoal Lake 40 members and allies, and a review of key documents. This was slightly modified from the original plan due to COVID, but it's all been done in consultation with community leaders. Shoal Lake 40 is an Anishinaabe community on the Manitoba-Ontario border. In 1913, the federal government approved the construction of a 150 kilometer aqueduct from Shoal Lake to Winnipeg to provide the city with clean drinking water. To this end, the government expropriated 3,500 acres of Shoal Lake 40 reserve land, excavated its burial grounds, and forced the community to relocate. In the process, Shoal Lake 40 was cut off from the mainland, becoming an artificial island. And all of this was done without consent and despite the written objections of community leaders. This situation has created many challenges, from people falling through the ice to the destruction of the community's commercial fishery and wild rice harvest. Then in 1997, a boil water advisory was imposed, and the government refused to build a water treatment plant because it was deemed too costly. Over time, Shoal Lake 40 made many proposals for roads, but they were always rejected. In 2001, the federal government considered a proposal for a bridge to the neighboring First Nation of Shoal Lake 39, but 39 opposed the idea because it would have required them to surrender lands for a public right-of-way. Out of respect for their neighbors' sovereignty, Shoal Lake 40 then set its sights on a 24-kilometer western road to the Trans-Canada Highway. This didn't seem to be a priority for any government, but in 2003, the announcement that a Canadian Museum for Human Rights would be built in Winnipeg presented a critical opportunity for change. So I'll now analyze how Shoal Lake 40 and core allies framed their struggle and the relative effectiveness of four main frames in appealing to target audiences, namely the human rights frame, Indigenous and treaty rights, social justice, and reconciliation frames. So perhaps the most salient frame focused on human rights in the context of the opening of the Human Rights Museum, the world's first museum dedicated to human rights, in which federal, provincial, and Winnipeg governments were highly invested. Shoal Lake 40 argued that having land appropriated and being denied road access and clean water were fundamental human rights violations. Moreover, Winnipeg had benefited at Shoal Lake 40's expense, and all three governments were responsible. If Winnipeggers and Canadians truly cared about human rights, the least they could do was help fund the construction of Freedom Road and a water treatment plant. Kyler Cotton, a longtime policy analyst and advisor to Chief Irwin Redsky, explained the Freedom Road campaign really took shape around the prospect of Winnipeg wanting to be a human rights capital. It was like the city put this big target, and we said, yes, this was an opportunity to make change. It absolutely was a specific strategy. It was framed that this was a stark contrast between the right to exist of an Anishinaabe community and the right of a non-native community to exist, and their so-called right to water. The picture on the right, by the way, is the CMHR building. With this in mind, Shoal Lake 40 took a series of actions to highlight the hypocrisy of a country and a city that celebrates itself as a human rights champion and yet benefits from human rights violations in its own backyard. In 2007, dozens of community members, led by the women, walked to Winnipeg and camped at the future site of the CMHR to raise awareness and advocate for Freedom Road. Irwin Redsky, who had been chief and was soon to be reelected, explained, it came to a breaking point where we were physically blocked. We couldn't get out. So it was just out of frustration, and we shared the story of our people to create the awareness, because Winnipeg sees themselves as a central place for human rights, and we didn't think that was right. Our rights were definitely not respected. Now, although the walk didn't immediately lead to funding commitments, it did gain some media attention and support, and it inspired community members to keep fighting. In conjunction with the walk, community leaders developed a campaign to embarrass Winnipeg and persuade governments to support Freedom Road in order to defend their own public image. Kyler recalled Sam Cates, then mayor of Winnipeg, had just announced the Human Rights Museum, and that's when we said, you can't be the human rights capital of the world and screw people over on their water supply. The plan was to put stickers on every water outlet in Winnipeg saying, Winnipeg water kills, Winnipeg water violates human rights. And he specifically recalled a meeting with the head of the water department saying, the First Nation needs this road to survive, and we need the city to support it. And if they don't, here's what's going to happen. And then he opened his briefcase and showed all the stickers and press releases ready to go. Soon afterwards, the mayor, who had staked much of his reputation on the Human Rights Museum, announced support for a feasibility and design study for Freedom Road, and the provincial and federal governments quickly followed suit. By 2014, though, there was little more progress, and the commitment of the Conservative federal government was especially in doubt. Upon learning that the Human Rights Museum would open that fall and that the museum architect would receive a prestigious award, Chief and Council then sent a public letter to the architect denouncing the CMHR as a, quote, shrine to Canadian hypocrisy. They also invited museum staff to the community to see and hear their story firsthand. And this visit became a national news event as Shoal Lake 40 selectively invited journalists to cover it. As a result, the museum, the mayor, and the Manitoba NDP government publicly acknowledged the, quote, injustice at Shoal Lake 40. But given the lack of firm funding commitments, especially from the federal government, community members then decided to occupy the museum grounds for 4 days. They set up a teepee and a sacred fire and attracted significant media attention and support. Chief Red Sky explained that the purpose was to, quote, peacefully educate people because many Winnipeggers didn't know. People would walk by and say, what are you doing here? Have a seat. Do you know where your water comes from? He also wrote an op-ed in the Globe and Mail where he astutely said, we do not want to have to take our kids to a museum to learn about human rights. We want them to experience it at home. So the human rights frame was very clear and compelling. But to keep the story alive in the media and on the public political radar, Shoal Lake 40 also opened their own Museum of Human Rights Violations on the reserve. Building on the visit from museum staff, they invited high-profile figures like David Suzuki, as well as politicians, academics, church groups, and human rights groups to come see life at the other end of the pipe. To advertise, they made these creative brochures citing the UN Declaration on Human Rights and saying things like, come view stolen lands and desecrated burial grounds, experience actual restrictions on your own freedom of movement, and risk your life accessing the museum. While this was partly in jest, it was also quite serious. They couldn't guarantee the safety of anyone who took the barge. You couldn't drink the water on reserve. And if you got stuck there overnight, there was no hotel. So many visitors described the experience as transformative, including the son of a federal MP who reportedly said, quote, I've got to tell my dad to get this funded. The Counter Museum included an information display, but also a community tour and the sharing of often painful stories by community members. And this experience seemed critical for a group of Winnipeg city councillors who visited in the fall of 2015. The very next day, Mayor Bowman announced the city's share of funding for the construction of Freedom Road. But human rights was not the only possible frame. Shoal Lake 40 situation could also be seen as an Indigenous and treaty rights violation. From this perspective, settler governments had a treaty responsibility to support Freedom Road. After all, Shoal Lake 40 is a signatory to Treaty Number 3, which they view as an agreement to share the land in peace and friendship, to respect one another's autonomy and support one another in times of need. Canada's Constitution Act recognizes and affirms Aboriginal and treaty rights, and the federal government, after initially opposing the UN Declaration on the Rights of Indigenous Peoples, has endorsed it as well. And some allies certainly viewed Freedom Road as in part a treaty obligation. Mennonite pastor who helped organize a rally outside the Manitoba legislature during a critical meeting between Chief Red Sky, the mayor, and the premier said, there is a responsibility on us as people and citizens of this country that is unique to us because there are treaties. How can we live in a way that respects and observes the treaty? And yet, while a copy of Treaty 3 was displayed at the Counter Museum, Shoal Lake 40 leaders deliberately downplayed this angle. Given the widespread ignorance about treaties and Indigenous rights in the Canadian public, they worried that if Freedom Road was framed this way, many settlers would assume it didn't concern them and may even view it as a threat to their own identity or rights. Kyler Cotton explained, if you're going to move anything claiming Indigenous or treaty rights, which are often seen as special rights, then you're not likely to get a groundswell of public support. You need it to drive deeper. And it was so obvious in the case of Shoal Lake 40, it was the human right to exist. Because if you're going to talk about treaties and Aboriginal rights, he continued, you've got to sit down and give them a history lesson and a legal briefing. It's not a language that's well understood without enormous education. And even then, you're likely to lose them halfway through conversation. So despite the support for Indigenous and treaty rights among some allies and decision makers, Shoal Lake 40 knew that appealing to the Canadian public and more conservative politicians would require a broader framing. As Kyler said, the left-wing activists were seen as perennial whiners and complainers, the usual suspects, and they were likely to support Freedom Road anyway. It's not them they had to appeal to. Third way of framing the campaign that appealed to many non-Indigenous Canadians was that it was simply a matter of social justice or fairness. Like human rights, fairness is often cited as a core Canadian value. The Manitoba NDP government was especially committed to social justice, and many religious groups, such as the United Church, stem from a social gospel tradition. So consistent with the human rights frame, the denial of road access and clean water could be seen as fundamental injustices, especially when Shoal Lake 40's conditions were contrasted with those of Winnipeg. To live up to Canadian, Christian, and social democratic values of justice or fairness, it was a moral imperative to support Freedom Road. Indeed, such language appeared frequently in Shoal Lake 40 speeches and press releases, and many community members and allies viewed Freedom Road at least partly in these terms. Kyler said the message they tried to instill in visitors was that they had a personal responsibility here. If you're feeling uncomfortable, if you're feeling bad about this, it's because you're benefiting from an injustice. So that's on you. So go fix you. And this message resonated widely. For example, upon reading in the paper about the denial of federal funding for Freedom Road, Steve Bell, a well-known Christian singer-songwriter, said he realized that it was such a very clear case of a fixable injustice. You know, we remove some people for our benefit, they deserve to be reconnected. 3 levels of government benefited, 3 levels of government should fix it. He went on to form a group called Churches for Freedom Road that convinced nearly 100 churches in Winnipeg to display signs saying, "We support Freedom Road." Not surprisingly, an NDP cabinet minister also said he was moved by, quote, the injustice of a First Nation that was relocated to provide water to Winnipeg. Something had to be done to correct the injustice. So again, in this context, broad appeals to justice and human rights were very compelling. The fourth and final frame, which was increasingly salient over time, focused on reconciliation. Shoal Lake 40's situation could be seen as a sign of the broken relationship between Canada and Indigenous peoples, and building Freedom Road and water treatment plant were literally concrete ways of working toward reconciliation. Putting it in these terms made sense in the context of the TRC, which had been documenting the genocidal effects of Indian residential schools, outlined 94 calls to action, and encouraged all Canadians to work for reconciliation. Key political figures, including Mayor Bowman, Premier Selinger, and Prime Minister Trudeau, had all made strong public commitments to reconciliation. And this was not lost on Shoal Lake 40 leaders. Chief Red Sky often said, quote, "Our story is the outcome of a trail of broken relationships, but it could be a story of the road to reconciliation." And you see this phrase picked up in one of the church signs to the right. Band Councillor Roxanne Green, who was a key organizer in the 2007 walk and the 2014 occupation, added, "We always threw in the word reconciliation every chance we had, just because we knew it would give more meat on the bones, you know, to remind them, if you're about reconciliation, then this is what needs to be done." To conclude my section, the Freedom Road campaign succeeded in part because Shoal Lake 40 leaders and allies found compelling ways to frame their struggle. The opening of the Human Rights Museum, the work of the TRC, and the wider political context presented discursive opportunities. In Snow et al.'s words, Shoal Lake 40 clearly linked their interests and goals with those of prospective adherents and resource providers. Human rights, justice, and reconciliation were salient ideas and values that had currency with key decision makers, the mass media, and large segments of the Canadian public. Many Canadians are deeply invested in a national identity and reputation as fair people and human rights defenders, and Winnipeg in particular has aspired to be a human rights hub. The Manitoba government made strong commitments to the CMHR and to social justice generally. As Cabinet Minister Drew Caldwell told me, I'm a pushover for anything involving human rights. It's an easy thing for me and my party to get involved with. Likewise, at the city level, a critical mass of Winnipeg councillors was committed to similar values and began to see Freedom Road in these terms. In this final quote from Scott Gillingham, we see a blending of the three main frames. He said, "This is a matter of justice. This is a matter of human rights. If we as a nation are serious about reconciliation, then we need to make sure that First Nations have access to the basic needs like clean water and road access." And finally, perhaps what was most impressive and effective about Shoal Lake 40's framing efforts was the message that Freedom Road was not an obscure or specialized interest, but rather everybody's issue. Shoal Lake 40 leaders highlighted how all Winnipeggers were personally connected and therefore responsible for change. As Kyler explained, so many people came to the community and said in the healing circle, "I got up this morning and bathed my kids. I washed. This is the water I drink. I am literally 60% of this water. This is me." They realized I am directly benefiting from an injustice and I need to change me. They weren't allies at that point, he added. They were changing their city. They were fixing their own government. They were fixing Canada. So ultimately, although the Conservative federal government never committed funding for Freedom Road, and although some settlers may not have been convinced, it didn't matter. Meaningful change happened because Shoal Lake 40 framed their struggle in ways that resonated with a critical mass of Canadians and decision makers, and they and their allies used brilliant strategies and tactics to ensure that the message was heard.
Miigwech, Jeff. I think in looking at the two case studies, we can make the observation that human rights framing was very effective in these cases. In both of the cases, human rights framing won out over a long period of time. We also see with these, both of these cases, that Indigenous and treaty rights framing came into conflict with human rights framing, that they rubbed up against each other, and that it didn't sort of get resolved, but it points out the difficulty of using Indigenous and treaty rights framing in Canada in pursuing these kinds of social justice struggles. Also, we see that effectiveness depended upon discursive fields and opportunity structure. In other words, the conversations that were going on in the society at large. The arrival of reconciliation discourse was very important and useful in looking at a resolution. It engendered a lot of goodwill on the part of many Canadians. And even though, as Chris Hiller and I've said, reconciliation can be considered a discursive hub, it sort of can be anything to anyone. And so there's a lot of conflict and tension around the use of the word reconciliation, but it can be very helpful. Not knowing what it means can be very helpful sometimes. And then to consider the conjuncture itself, and that is strategic use of frames. And in both cases, we see very careful consideration of how we should pursue anything in particular, how we should frame it, how we should promote a particular perspective. Yeah, okay, so I'm just checking to see if Avril has been trying to come in, but we haven't yet achieve that. But to understand the conjuncture is so important.
I am here, Lynn. Sorry.
That's wonderful. Have been looking forward to engaging with Avril and having her response and engaging in some discussion with her. Miigwech. So
Okay, okay.
Jeff, if you can stop sharing your screen, I think. Yeah, there we go. Good to see you. Okay, so we're going to introduce Avril. So Avril is a Pakeha New Zealander from Aotearoa. She is a faculty member at University of Auckland. Her research centers on the legacy of settler colonialism in making sense of Pakeha identities, New Zealand national identity, and Maori Pakeha relations. Dr. Bell is currently president of the New Zealand Sociological Association, and we met Avril at an international symposium she organized and hosted in February 2021 called Settler Responsibilities Towards Decolonization. So kia ora, welcome.
Kia ora. Thank you, Lynn. Tēnei te mihi kia koutou. Tēnā koutou, Lynn, Dawn, Jeff. It's really great to see you, and it's really an honour to be invited to be part of your session in your panel today. I have to apologise for my lateness. I seem to be having a lot of difficulty with time differences, and of course I'm sitting here in Auckland where it's early in the morning, but for some reason I don't seem to be able to cope, even though we have world clocks on phones and things. So my apologies for being late. I also, I want to acknowledge I wanted to acknowledge the people who have been, working for decades, the Indigenous communities and their allies who worked for decades on the struggles that you have been talking about today as well, the right to belong and Shoal Lake 40 struggles, massive amounts of work and effort that people have put in over such long periods of time. I also wanted to say something about the effort you have gone into as researchers in wrangling all this together, because this is such a massive, impressive project that you're engaged in, looking at these long-term struggles. And, I can't imagine what it's like trying to wrangle all the data and coordinate everything that you've done. So that's much appreciated. Important work that you're producing. Looking forward to the book that's going to come out of all of this. In terms of what my role is today, hopefully I've can contribute something here. I just wanted to make a couple of points about the use of human rights discourse, I suppose, in particular in relation to Indigenous struggles, and say something about some of the ways that rights discourses are being used in Aotearoa, New Zealand at the moment, and then ask a couple of questions in relation to your work, and hopefully not talk too long so that there's plenty of time for others to chip in. And it's interesting, the whole issue of human rights in relation to Indigenous rights, because there has been a kind of a tension, I suppose, or an international kind of debate about human rights, right, as a Western discourse that's kind of being imposed upon people and doesn't necessarily take account of the ways that they might understand. I have to use the language of rights because I haven't got another language. They might understand the roles and the statuses of different people or different people in relation to the environment and so on. So there has been this kind of critique of that kind of rights discourse for being a kind of almost a colonial imposition in itself. And of course, the other significant tension around human rights discourse in particular is the way that it's been very individualist. And for communities like Indigenous communities, there's that tension between the individual rights and collective rights. that sometimes comes into play. But on the other hand, it's obvious from the work that you've done, and it's obvious, I think, you know, in other cases as well, how resonant the language of human rights is, you know, and how deeply felt those kind of ideas are about, you know, the individual's right, or collective rights, I guess, for that matter, but the individual really. You know, and how you've shown how effective that kind of argument has been in these two cases. People get the idea of human rights, don't they? They get that argument. And you've also talked about how important the idea of fairness and social justice is in the Canadian society and the Canadians' view of themselves. I think that's something we share in New Zealand. We have this idea of ourselves as fair-minded people. So they're really powerful discursive frames for political movements, really powerful, and as you say, making it everybody's issue, and therefore useful to mobilize support and to mobilize the support of power brokers. I think another thing I noticed listening to you and reading your paper was in the case of Shoal Lake 40, that a really powerful dimension as well is the fact that the injustice, at the heart of the injustice, was the public water supply for Winnipeg. You know, so that was really significant for non-Indigenous people to see themselves as implicated in the struggle, as being, you know, as that lovely quote from somebody, I can't remember who now, if you're feeling discomfort, it's because you're benefiting from an injustice, you know. Okay, so then just kind of shifting focus a little bit, thinking about the difference between these two struggles that you've talked about. Both campaigns are directed at the government, you know, the federal government and or provincial government, I think in the case of Shoal Lake 40 anyway. But because the right to belong struggle was about Indigenous women's rights to community membership, there's also that kind of tension between the Indigenous communities, and sorry, I haven't even got the correct language for what for these communities these days anymore, and the women, right? So it was kind of seen as a zero-sum struggle. If the women were given the right to membership, the communities in some way are losing out because of the context, as I understand it, where the federal government, under the Indian Act, I guess, the resources are not expanded on the basis of membership, and there's no kind of expansion of land areas on reservations or whatever. So whereas for Shoal Lake 40, when they came into some kind of conflict with Shoal Lake 39, collective, different kind of thing, they were able to kind of rethink their plan and decide to argue for a road to go in a different direction. So for the right to belong, the struggle was much more complicated and fraught in that sense, in terms of strain on the relationships within Indigenous communities and between Indigenous people. And I think that's, yeah, I want to come back to that when I ask a question. But in another, I think, notable feature of both these cases that you've been talking about is life and death is at the heart of them as well, right? You know, women, the importance of the link to be made between the right to belong struggle and the Murdered and Missing Indigenous Women and Girls campaign, to really help bring that home to non-Indigenous Canadians as well, I guess. What was at stake here? And obviously in Shoal Lake 40, people literally lost their lives trying to cross the lake. You know, so that's a really, it's depressing that Indigenous issues have to get to that kind of point before they get some traction at sometimes, but it's a sad indictment of our kind of colonial contexts, ongoing colonial contexts here as well as there. But I just wanted to say, so some kind of comparative points or something about Aotearoa compared to Canada. I think human rights and fairness discourses are both really powerful here and effective here as well. Reconciliation, on the other hand, is not a language that is used here at all, which is really interesting. I think effectively there is a kind of discourse of reconciliation that works when the government is making a treaty settlement with a particular tribe, and in the apology that they give, they talk about wanting to rebuild relationships into the future, which is kind of reconciliation language, but it's not something that is percolated out into the wider public discourse. We haven't had anything comparable to your Truth and Reconciliation Commission that would facilitate that, although actually saying that at the moment there is a inquiry into, it's called Abuse in State Care, which is actually quite comparable, about the abuse of children who were, disproportionately Māori, who've been taken into state institutions as children. But what we do have, I think, a much more widespread treaty discourse, right? Or Indigenous rights discourse, or treaty in particular, because we have one treaty, which makes it easy in a way, but also because it's kind of interesting to think about this. It's become the treaty, or te tiriti, which we more and more we're using the Māori terminology to talk about it, because there were actually an English language version and a Māori version, and the Māori version is the one that was agreed to and signed. So since like the 1980s, we've had our national identity discourse has changed to one of biculturalism. I know you have biculturalism in Canada too, but it's different. But so here it's been, so there's a whole generation who've grown up now with this idea that New Zealand is a bicultural country and the treaty is the founding document. So the treaty is quite prominent in our sort of sense of identity. Does not mean we live up to it, right? Or that we easily concede around Indigenous struggles. But it does mean that that language is much more prominent in public sector, I guess. And of course, I think probably same there, the treaty discourse is one that really centers sovereignty, right? So the issue of Indigenous political rights and collective rights. But we don't have, unlike you in Canada, we don't have any self-governing territories, reservations or anywhere like that. So Māori struggles for political sovereignty take place across society, everywhere, in sort of different institutions. So within health, the health sector, the education sector, the structure of the political system, anywhere you want to look, there may be Māori kind of struggles for political autonomy or co-governance as a terminology that's very prominent at the moment. And the opposition, right-wing opposition parties, in fact, are accusing our current government of wanting to bring in co-governance by stealth, that they are trying to, they're kind of indigenizing the country sneakily without us having a public debate about it. I don't know the ins and outs of that, but there are lots of changes happening. For example, our health system is being reformed at the moment, and there's going to be a New Zealand Health Authority and a Māori Health Authority. So they will be co-governing, with the Māori Authority having a lot of, capacity to organise Māori health provision and decision-making and so on. And we're also reforming our water infrastructure nationally. And that again is going to involve co-governance between Indigenous communities and local councils around the management of water resources. I just want to say, can I give one more example or something? I don't know how the time's going here. A case that's current at the moment, which is where there's a clear tension between individual and collective rights, is around the institution of Māori electorates in local government, our local government councils. We don't have provinces like you, we just have local councils because we're a tiny place comparatively. We now have a law that allows councils to have special Māori electorates within their electoral system. And one particular district council, Rotorua, has tried to create a system where Māori and non-Māori have equal number of seats that they can vote for. So the system they're proposing is that each side would get to vote for 7 councillors. But the Māori population is only a third of their electorate. So that is our Attorney General has ruled that this is discriminatory and they can't do it, because for once in the 180 years, it would actually be privileging Māori voters, if that makes sense. You know, Māori as individuals would be getting more rights than non-Māori. So that's the sort of things that are happening here at the moment. I guess the other thing that's happened in New Zealand, I don't know has happened in Canada at all, maybe is on the agenda, is the use of human rights, or other than human rights, the extension of human rights frames to nature, right? So we have had 2 acts of parliament passed that have given kind of personhood status, in one case to a river, and another case to, it used to be a national park. I don't know what they call it any longer. It's been returned to the tribe of the area. And there are, of course, human beings who have to ensure that the rights of those natural entities are protected, but they have that kind of status of personhood in the law. Just getting back to your work, it's, and I wanted to kind of ask a question around the Right to Belong campaign and that struggle that I was talking about before, or that tension or conflict between the Indigenous women in that case and various Indigenous leaders or Indigenous communities who are concerned about the effect if they were allowed, and then their status was restored. Would it be fair to say that if the resources available from the federal government could have been expanded, and that so that basically that communities were resourced on the basis of their population appropriately, right? So that if you've got a bigger population, you get more money and you get whatever. That struggle would have played out differently, you know, if there wasn't that kind of tension that was the tension was created by the federal government effectively. And also, have there been coalitions between Indigenous groups to try to get that funding model changed? I think so. Yeah, I just put that question out there.
So actually, this is one of the most tragic ironies of this entire debate, is that at the time of this court case, in fact, most communities were still in a relationship with the federal government where their funding was a per capita relationship. There's very few who have actually, as part of self-governing, some have gone to a different agreements. But it was interesting that was very much hidden, and Indigenous women and children were positioned as they were going to be a burden. We already don't have enough housing. We already don't have enough, you know, of all of this. And so that was part of why the registration on the national list was separated from membership in a specific community. And up until a few years ago, in fact, the one leading community that fought very hard to not to allow back the women and children was the Sawridge Indian Band out west. And Walter Twin was leading that charge. And then his sister took it up after he passed on. Literally for decades, they continued to fight. This is not a remote First Nation that has no housing and mold. This is actually a very oil-rich community that has treaty annuities, oil annuities, royalties for every community member. So it was, in fact, about the division of resources. Now, that particular community, I was talking to the sister a couple of years ago, and she says that she now regrets having continued that challenge, because their community now realizes that as of a couple of years ago, before the changes on the status, they were down to their last status Indian child. So you can fight for your treaty rights all you want, but if you don't have any more status Indians to exercise those rights or to defend them, everything goes back to the crown. Everything goes, and it was all have been pointless. But one of the other things was that the human rights of Indigenous women were pitted against the Indian Act in a way that was making Indigenous women's wanting human rights a threat. You know, the fear that opening up the Indian Act, which is essentially the piece of legislation that protects what little bit we have left, you know, our last 0.5% of our territories. is protected under the Indian Act. And so there was a fear that opening up the Indian Act would threaten that last little bit we have left. But at the same time, there were others who said, well, the whole problem is the Indian Act, and we need to stop complaining about who gets in, who gets back in, and just throw out the Indian Act. But one of the concerns we have as women, and we said, if we are going to throw out the Indian Act and we are going to have something replace it, and we are going to have conversations about what is going to replace it and what our rights are going to be, we as women, those women and their children and grandchildren, need to have a seat at the table to be part of those conversations on what's going to replace the Indian Act or how that's going to change. And that's why it was so fundamental for us to continue to fight this challenge to make sure our women and children were returned, so that we can have voices at the table for what is going to happen for the future of our lands. And that was a really critical process issue that some people were trying to say, well, we just need to throw out the Indian Act and stop wasting your time on this argument. But we needed back in before we talk about throwing it out and starting over with something else.
Complicated. Yeah, and it's interesting, isn't it, how, because for Indigenous communities, you're stuck inside this colonial structure, and there's a kind of, it offers something, but it's not right. It's not good enough. So you can get well, I guess co-opted is one of the kind of terminologies that might be used for that. But yeah, you get a vested interest in it. I had one more question, if I've got time to do that. And I was thinking about the UNDRIP, the United Nations Declaration on the Rights of Indigenous People, and the significance of that so far in Indigenous struggles in Canada. I think here it's present in it's actually present at the moment and more visible at the moment. We, like you, were late to sign, voted against originally. But the current government the government that decided to sign actually said, well, we're signing it because it doesn't actually matter. It's just aspirational. It's, who cares, basically. But the current government is talking about what can we do to meet our obligations under that as signatories to that declaration. So they are making moves in that direction, hence the language of co-governance, I think. So what's going on in Canada around that? Is there kind of much reference to that declaration in support of Indigenous struggles? And do you think it's a growing point of leverage for Indigenous communities? That's a question for anyone.
Jeff or Lynn, did you want to jump in? I don't want to monopolize.
Just say something quickly. I mean, I think it is a growing point of leverage. It's not necessarily widely known or accepted in the general public, but the federal government recently passed legislation that, at least in principle, is supposed to bring all Canadian laws and policies in line with UNDRIP. So that's pretty incredible if that actually happens. But that is what the legislation kind of calls on them to do, that was brought in by the federal Liberal government very recently. And some of the key allies involved in the Freedom Road campaign in Winnipeg were helped to lead the charge to gain public support for that bill, to help pass that through the legislature. So that's an interesting connection as well. So like there is that tension again between human rights versus treaty rights and Indigenous rights discourse, but some of the most closely involved allies did have a very good understanding of treaties and Indigenous rights, and went on to support UNDRIP and pushing the government to actually enact that and implement it in laws and policies.
I would add that KAIROS Canada, which is one of the case studies in our research, was very involved, highly involved in supporting the agenda to get UNDRIP passed. And so, my sense is that people are still trying to figure out the implications. We recently asked that question to a chief that we were working with in a training, and he said, we're just studying it now. And so I think figuring out how it interplays with constitutional aspects of constitutional arguments and court decisions, all of that is being worked out. So it's premature, I think, to really comment on how that might play out, but it will.
Yeah, sounds similar.
Actually, I think what was really interesting too, one of the things, we just did a training, we said, with a local municipality. So I do think a lot of levels of government, from the municipality up to the provinces, are just trying to understand, what this means for them. And we were sort of having that conversation yesterday about, well, if we're doing lands planning, if you're creating your plan and there's traditional Indigenous sacred burial grounds or, critical archaeological areas within your territory, what does this mean for you? And what's the good process of ensuring that Indigenous people are included in that conversation at the very beginning, not at we have developed this wonderful archaeological drawing and spent millions and all these plans, and then you take it out and everybody goes, oh, you should have come talk to us first. And but by then people are really invested. They've invested literally millions of dollars. So trying to unpack that a little bit and have municipalities sort of understand, as you said, what is their sort of obligation under duty to consult, as well as what is the appropriate thing to do that helps to, when we talk about, there's a question there about interest convergence, to show everybody that in fact, having Indigenous people have basic human rights, have access to clean water and basic health and education and rights for women, is actually in everybody's best interest here in Canada. It saves, a small amount of upstream investment in our communities has significant savings for the government in the long term. I mean, we can show even within our Native Women's associations, we've worked to keep by just keeping 75 families reunited instead of having the children apprehended, save the provincial government over $50 million just on those 75 families. So imagine, if everybody had access to basic quality of life in Indigenous communities, how much it would save the government. And that is very much in everybody's best interest. So I kind of, that's the expanding our framework of understanding human rights to include Indigenous people and First Nations communities as having basic human rights is about interest conversion, that is in everybody's best interest. And I think, as we said in the whole start of this conversation, by making this everybody's issue, we've really been able to, that's when we see change happen.
Mm-hmm. Good. I know that we have to end this session. We've received messages from the organizers now, or rather the technical people. And I just want to say miigwech to everyone, and particularly Avril for persisting. And I can't imagine what time it really is where you are right now, to have this conversation. It's been a very intense and rich process working on this session, working on a paper that goes with it. And we just want to say thank you so very much for inspiring us to keep going and formalizing our thoughts around this topic. Miigwech.
Well, thank you all very much for inviting me. I don't think it's up to me to say the last word here, I think, but I feel quite humbled.
There was one other little point I wanted to make, if I have a minute, about you mentioned about the human rights being a critique that it's a Western discourse imposed on people. And I've heard that as well. And there is something to that for sure. But I think part of the point that I'm trying to make, that we're trying to make, is that Indigenous people are strategic thinkers with agency, and they can choose to use these things or not. And they have always adopted and incorporated ideas from one another's societies. It's just that they need to be free to choose to be able to do that or not. And they have the strategic sense and the agency, and we see a very clear case of people doing that in both of these cases. So.
To your point, Jeff, as my grandma would say, people can talk about post-colonial and talk about Western, but they're not going anywhere. We got to, and if that's the discourse that we're living in, we need to figure out how to make it work. And the denial of Indigenous human rights has been sort of the foundation of colonization from the beginning, right? That taking away our rights as human beings and building that into the Indian Act, our I mean, we weren't even considered persons under the laws of Canada until the 1960s. So yeah, it is a Western construct, but so is all the rest of the legislation that surrounds our lives. So we have to make sure we can, when we can, make it work to defend ours, and go against that history of taking away our basic human rights. Thanks for bringing that up, Jeff. That's a really good point. So my grandma used to say, did I miss it? Did they all leave? Just when we used to talk about post-colonial. We're like, no, Grandma. So then there's no post-colonial. They're still here. It's still colonial.
Okay. Miigwech. Thank you to everyone who attended this session. I hope it was I wish we had more time just to engage with one another.
Thanks, Avril, and thanks everyone for coming.
Okay, thank you.